My name is Harley Moore Wilson. I work with the Native Agricultural Financial Services. We are a uh, reliable and trusted partner in providing capital to support agricultural production, rural business development, and rural infrastructure for Native American farmers and ranchers and agricultural communities. We are really thankful that each of you are here. We're extremely grateful to be a partner with the Southern Risk Management Center. The Southern Risk Management Center provided the funding for this webinar, and this webinar is specifically targeted to the Ag FTAP program, which is Agricultural Finance, Tax, and Asset Protection Education Program. This seeks to enhance farmer and ranchers' ability to understand and navigate the farm, business, tax, and asset protection decisions for their operations, as well as important relationships between federal income taxes and USDA farm programs. Today, Ridge will be your presenter, and I will let him take it over. But before Ridge starts, because I've forgotten already, if you have any questions, feel free to put them in the chat or wait until the very end of the presentation, and I will allow everybody to speak, and you can ask questions freely that way. Go ahead and take it away, Ridge, and thank you guys for your time.
Thanks, Harley. Like Harley said, my name is Ridge Howell, and I am legal counsel for Native Agriculture Financial Services. I grew up here in Oklahoma, about 2 hours away from Oklahoma City right now, in a small town called Shakota on my tribe's reservation. Today, we are going to be going over two primary topics, and that is business entity selection and then land tenure. And we're going to essentially be trying to answer the central question of why you should choose a formal business structure for a farming or ranching operation, and really how to evaluate the six most common entity types for everything from formation to operation to taxation. And then after that, we'll move on just one subject over to land tenure. We'll talk a little bit about different types of land statuses and how that might kind of guide your decision in selecting an entity and provide some considerations for you. So I thought it would be helpful to start off this entity conversation with a little moniker. I've got locate here, and it gives us an overview of six and seven. There's one that didn't fit the locate framing. Um, but just considerations that you should have anytime you're thinking about changes to your business structure or potentially starting a formal business structure for the first time. So if we're going down the list, we've got liability, ownership and management, capitalization, or how do you set up your business financially, authority and formalities. So who makes business decisions, what formal agreements are in place or not in place that guide how the business is run. We'll talk about taxes. That's always so important and really relevant to choosing the correct entity. And then we'll also touch on estate planning and transfers. Starting out, though, we first look to liability, which really could be a highlight of why you should choose a business structure. Choosing a formal business structure, you have the option to protect yourself from personal liability. So if you've got a farming operation and you've also got a homestead, if something goes south, how do you make sure that your home where you live, your necessary equipment, all of that is protected from liability in cases of something bad happening? We also think about liability as it reflects on financial and personal injury or property damage. And then just want to keep in mind that even though we're talking about liability throughout this and why you should choose a business structure that protects you from some of that, I want to emphasize that liability, even through a solid business plan, is not a replacement for insurance. And it's something that, you want to consider whenever you are choosing that entity. So basically, how do you react when something goes bad on the farm? Perhaps you have a farm worker that is injured while operating your machinery, or maybe some harmful bacteria enters your dairy operation. And we're just essentially going to the question of who will be responsible for any damages resulting from that lawsuit and whether or not you as a person are personally reliable. Continuing on to taxes. Um, this is another really huge area for entity selection. And that comes down to two basic considerations. That's whether you want to choose a business structure that is taxed doubly, so at a corporate and personal level, or whether you want a pass-through taxation structure that allows you to be better off whenever tax time comes around because you're not paying for both the entity and for your personal taxes. Um, Kind of diving a little bit deeper on what those two types are. In a pass-through entity, which includes sole proprietorships, LLCs, partnerships, or S corporations, all of which we'll talk about in a little bit. In those entities, you have a pass-through tax structure, which means the business does not file or pay its own federal income tax return. Instead, the business's net profit and losses flow directly to the owner's personal tax returns. So that means that income is taxed at the owner's individual tax rate. And you also could have potential eligibility for things like a qualified business income deduction, which in certain circumstances can take up to 20% off of business income. While this is frequently looked at as a better option than double taxation, it's important to recognize that this is not a tax-free option. It merely means that the pass-through entity does not pay the tax, but the owners of that entity still owe income tax and potentially self-employment tax on those profits. Switching to double taxation or entity taxation, that's when that's the default operation for C corporations, which are legally viewed as a separate entity from the owner. There are some different types of corporations that you could have double taxation on. But essentially, it means the corporation pays taxes as the corporation, and then whatever profits and losses come from your involvement in that as a shareholder, you also then would pay your own personal taxes on those profits and losses. And then just important to note, we're talking about some legal aspects, some tax aspects, but this is not any kind of advice. This is simply an overview. And if you are interested in creating a formal structure or really discussing what tax layout looks best for your operation, it's really, really important that you not only consult an accountant, but also an attorney, because it's that combination of those two skill sets that can allow you to safely get into an entity and set up your tax structure in a way that will make sure you're compliant when tax time does come. You also want to consider ownership and management. This is really a question of flexibility versus rigidity. How do you want your day-to-day operations to go forward? How are business decisions made for the company? How hands-on or hands-off do you want to be? These are the kind of questions that really frame whether or not you want a flexible business structure or a really rigid business structure. And there are times and places where both of those are more appropriate than the other. For example, in a partnership, do you want to be a general partner that's responsible for all decisions on the farm? Or maybe you'd rather be a limited partner where you can enjoy some of the benefits from the work, but leave that day-to-day operation and management to the established general partner. Um, Again, just kind of a side that we'll discuss more a little bit later, but LLCs are often viewed as the ultimate flexible entity structure. They basically can be as detailed or as not detailed as you would like. But because that flexibility is there, even if you want a more rigid structure, you still can achieve that through a solidly put together operating agreement. You also want to consider authority. This is broken up into three different types of authority, and those have some subparts as well, but kind of focusing in on the categories or the big umbrellas, you've got individual authority, which is essentially who can legally bind the entity. With somebody who has individual authority for an entity, they have the explicit granted right to sign legal documents, um, make promises on behalf of the entity, essentially sign for the entity. Ownership authority is a little bit more nuanced because it goes to who actually owns the business, who receives profits and losses, who has the ultimate voting power. And at times, this can be the same person that has that individual authority, but at other times, this person, basically they're the last in the line and they've got ultimate say, but they might not be involved on a day-to-day basis. And then finally, you have business formalities, which is what I like to think of as administrative work. These are the legal processes and structural requirements a business has to follow to maintain its legal status and keep the owner shielded from any kind of personal liability. You also want to consider capitalization. When we talk about capitalization in this context, we are talking about, or we're referring to how your operation is funded and how business assets like land, machinery, and livestock are transferred into the entity. So they're transferred from somebody's personal property into the entity's property. So it dictates how you establish your farm's capital stack, whether that's through personal investment, equity from partners, debt, and so on. It's important on this, those first 2 points. Capitalization might look like in-kind contributions. That might be how your business is capitalized. And you also have the opportunity to say, if you've got a farm and maybe you have a sole proprietorship on one hand and an LLC on the other. You've got that option to say, no, this tractor belongs to me and it is part of my sole proprietorship. Or you could transfer it into the entity and essentially make that the entity's property. Um, Fixed transfer and estate planning. This is something that we could and have talked about to no end. But it's just the process of facilitating a transfer of shares or units instead of individual assets. It's the transfer of your ownership structure through a will or a trust. It's basically just how you plan for your farm to continue after you're gone. Sometimes this provides protection for the retiring generation, such as with limited partnerships, where you can protect that generation by allowing them to transition wealth smoothly while maintaining some control of the underlying assets. By acting as a general partner, the retiring generation can retain that decision-making power, while the limited partners, who maybe are the next generation in the family, receive ownership with limited liability, all while protecting the family legacy and creditors from lawsuits. And then finally, always it's important to keep in mind the 5Ds. This is something that we talk to with individuals who are considering an estate plan, a will, or a trust. And these 5Ds are something that almost everybody encounters, at least one of them in life. And that's death, divorce, disability, disagreement, and distress. So, how does your operation function? How does it continue on when one of those 5Ds comes into play? And all of that ties into the business structure that you want to set up because that will dictate how it's transferred in the end. And then finally, the portion that was left off our locate, we've got government programs. There are a lot of farmers and ranchers in Indian country, outside of it, who are involved in farm programs, whether it's something NRCS related, perhaps a commodity crop program. There are different ways that the federal government and sometimes state government comes in to support and lift up farmers and ranchers, whether it's in a time of distress or not. And that entity status that you select will have likely a pretty big impact on what you're eligible to participate in. So as you see on the slide, payments can be impacted by legal entity type and structure. Almost every federal program has a AEF or actively engaged in farming requirement to be eligible for that program. This can look different across different programs, but generally it means that you must make significant contributions of land, capital, or equipment, and active personal labor, active personal management, or a combination of both in order to satisfy that AEF requirement. And then finally, payments can have per person and or per entity limits. This can come into play whenever you're talking about things like your adjusted gross income threshold. So all of these considerations go into what entity selection is best for your operation. And then again, we've just got that list, locate, of 7 factors to consider, or 6 on this screen, of liability, ownership and management, capitalization, authority and formalities, taxes, estate planning, and transfers. So we've kind of covered some of the basics of why you might want to create a business entity, but more specifically, why should you? Generally, while ag businesses can be run without a formal structure, this is usually a bad idea. The business operator's personal assets will be at risk from business debts and liabilities. Available tax benefits may be lost, especially when you're talking about a larger operation where there may be one or more employees underneath the owner or the operator. And it also is important for managing assets, capital investments, and operational structure when there's more than one person. Um, while I know a lot of times us in the farming and ranching communities can be informal and very, collegiate, I guess, about how we interact with each other. At the end of the day, we have to keep in mind that if we're engaged in the practice of farming or ranching, we're engaged in a formal business, and that comes with benefits and consequences. And some of those are lost if you choose to stay in the sole proprietorship. So finally, we come to the 6 most common business structures for farming and ranching operations. We've got a sole proprietorship, a general proprietorship, or that should be partnership, not proprietorship, a limited liability company, limited partnership, and then C corporations and S corporations. Starting off with sole proprietorships, this is oftentimes the most common business structure that a farmer or rancher is engaged in. And that's because if you are engaged in farming or ranching and you're not on somebody else's payroll for the work that you do, you are a sole proprietor. It's the automatic designation that the law gives you whenever you don't choose to become something else. So, sole proprietor, if you're paying your own way, you're not on a payroll, that's usually what you automatically are. Um, Generally, they're really easy to set up. It's easy to conduct business activities through a sole proprietorship, and it's really easy to maintain compliance. Sole proprietorships are not technically separate from the owner, so all of your assets in the sole proprietorship are intermingled with personal assets. Business assets and liabilities are owned by the business operator. There are no corporate formalities, so you don't have to create an operating agreement, create bylaws, engage a board of directors, anything like that. But as we've kind of been hinting at, this comes at a big cost. If you're a sole proprietor, you are held personally responsible for all business liabilities. That means if something goes down on the farm or ranch, and there's some kind of liability implicated, you will be personally responsible. And if your farm or ranch operation isn't able to cover those expenses, then you have no option to go into personal or pursue something like bankruptcy or foreclosure in worst case scenarios. Just a quick question, which I know y'all aren't in a spot to answer right now, but in a sole proprietorship, is the spouse of the sole proprietor rendering their joint marital assets for purposes of business debt liability? So to kind of expand that or give more context, let's say a husband and wife have a farm. The husband operates the farm as a sole proprietor, and they also have marital assets, some of which may be just the spouses, just the wives, or a combination of both. But in that situation, if there is something that implicates the business's liability, the spouse's assets, even if she's otherwise totally unrelated to the farm or ranch operation, her assets are held in as liable to cover any damages from issues that arose on the farm or ranch. So, driving it home, this is easy. This is typically what you are if you haven't created some other type of structure, but it comes at a great cost if you are ever in a financially distressing or bad position on the operation. Sole proprietorships are pass through, so taxes for them are included on your Schedule F or your Schedule C on 1040. So you would report business income on your personal tax return. Partnerships. Under partnerships, we've got both general and limited partnerships. These are very similar to a sole proprietorship, but they include two or more individuals. They're very easy to set up and similar to sole proprietorships, there oftentimes aren't any formal agreements, paperwork, or other documents that memorialize the general partnership. Any workload is shared between the partners. And generally, you've got more assets with more people. So a general partnership could continue to grow and continue to, create a stock of assets. Uh, Unfortunately, similar to a sole proprietorship, all partners' personal assets are available to satisfy business liabilities. But there's no guardrail between business debts and assets and personal debts and assets. If you were to need them for some reason, then in any type of court proceeding or bank proceeding, they would be able, whoever was on the other side with your creditors would be able to come after your business and personal assets because for purposes of this, they're essentially the same. Um, a really big downside for general partnerships is you've got a lot of room for personal conflicts. And because these are often not governed by any formal agreements, you could end up in a spot where you don't have any formal mechanisms to address these conflicts. However, you can create a partnership agreement, which could memorialize how you want to run business on a day to day basis, decide on the course of the business, and generally make decisions, and just basically give yourself the structure that you think you need in your business operation. Like I said, there's also a limited partnership similar to the previous. This involves two or more people. However, in a limited partnership, the general partner oversees the business. The other partner or partners are considered limited partners and they don't partake in any of the management of the business operations. A general partner's personal assets are exposed to business liabilities, but a limited partner's personal assets are not. So this could be a potentially better option if you're looking for an easy to create entity that had some flexibility in it and also wanted protection from that liability. Uh, Pass through taxation, just like a general partnership, is how this tax structure works. So any of your um, debts, assets, dividends, all of that stuff will be passed through to your personal tax return. And again, we've got just kind of a visual of what partnership taxation looks like through this. Partner share of profits passes from the partnership to the individual's returns. This is done through a Schedule K-1, which is an IRS form used to report an individual share of income, losses, deductions, and credits from a pass-through entity. For partnerships, all business income is subject to self-employment tax, but there is no income tax paid at the partnership level. My favorite, arguably, limited liability companies, an LLC. These are separate legal entities that may have as few as one or many more members. Owners of the LLC decide how to be treated for taxes. Typically, this looks like pass-through taxation, where members pay income tax individually on any profits or losses from the business. Personal assets, crucially, are not available to satisfy business liabilities under an LLC. This is why it's frequently put forward as the best or most flexible option for a wide range of people, because you've got the ability to both have a favorable tax structure if that's what you're looking for. You've got ultimate flexibility in how formal you want the operating agreement to be. So you could be very, very specific in how the business is run and decisions are made. Or you don't have to. Most states do require an operating agreement, but a lot of times this can look like a very, very, very simple agreement that just memorializes the creation of the LLC. And again, members and owners are generally protected from personal liability for business debts and lawsuits. And fortunately for people in general, LLCs are pretty easy to create. While it's always advisable to seek the advice of an attorney in your area, most states don't require this, and there are simple applications that you typically file with the Secretary of State to create that LLC. Looking at the LLC taxation, similar to partnerships, LLCs pass through tax through the K-1 form, which accounts for their share of income, losses, deductions, and credits, and then they pay it on their personal tax return. You are subject to self-employment tax. Following on to C corporations. C corporations are a completely separate legal entity from its owner, and C corporations are technically owned by the corporation's shareholders. When it comes to liability, there is no stronger protection than a C corporation. It's got the strongest level of liability protection, and shareholders' personal assets are fully shielded. Um, some of the downsides of C corporations come during tax time, however. While income is generally distributed to shareholders as dividends or salary to working owners, this is taxed at the individual owner's rate in the tax return. This scenario is referred to as double or entity taxation. And what it means is simply that the corporate income tax is paid plus excess retained earnings and potentially subject to accumulated earnings taxes. So potentially you've got more deductions through a C corporation and lower self-employment taxes, but that may or may not outweigh the double taxation that comes with this structure. Corporations, like I said, protect personal assets from business liabilities stronger than any other type of entity selection. Corporations' protection of personal assets do require strict adherence to certain practices, such as no commingled funds or corporate formalities. Corporations also require a strict governance structure. That's where we come in with shareholders, board of directors, officers of the company, all of which have different roles and responsibilities within the corporation and different levels of authority making or decision making authority. And finally, it's really important to be sure that the operation has enough money, that they're sufficiently capitalized, and keep the corporation's financial affairs completely separate from the shareholders' financial affairs. And then finally, on this, corporations, like we mentioned before, are governed by a board of directors and corporate office holders. You do have to draft and file articles of incorporation with the state that you're incorporated in. And you also have to have strict adherence to those bylaws. Generally, corporations have to hold an initial organizational meeting where they formally adopt bylaws, elect officers, approve issuance of stock, and issue stock. You can create a shareholder agreement if the shareholders want one, but it's generally not required. And you do have to hold annual meetings and again, adhere to those formalities. This is really, really important for corporations. You've got more standardized legal documents that are required to create a corporation than probably any other entity type, or arguably any other entity type. The downside or potential downside of this is if you don't strictly adhere to those formalities, many of which you do create on your own whenever you're setting up the organization. If you don't adhere to them, then something called piercing the corporate veil happens. And that essentially is a legal mechanism where it says you have commingled your personal and business finances, or you've gone against some of the formalities in your bylaws or articles of incorporation and commingled that totally separate entity from your personal affairs. When that happens and somebody pierces the corporate veil, you lose protection from all personal liability. So while they are structured to be strong and safe, some of that structure comes with additional requirements that are important in order to keep that protection from liability. And then we just have a visual of how C Corp's tax structure is organized. C corporations pay their own taxes and pay wages, rent, and distribute dividends to shareholders. So that is taxed. Then whatever wages, rent, and dividends the shareholders received are also then taxed on the shareholder's personal tax return. And then finally, we've got S corporations. Uh, an S corporation is a special tax designation that allows some C corps or LLCs to avoid double taxation. It provides the same level of liability protection as a standard C corp. And you again have that added benefit of pass-through taxation, where profits and some losses pass through directly to the owner's personal income without being subject to corporate tax rates. Um, S corporations are similar in structure or in creating it to C corps. You are required to pay salary to shareholders. There are many formal rules and procedures that many more formal rules and procedures than you would see in something like a partnership or an LLC. But that personal asset protection is there if all of the corporate formalities of the C Corp are followed. So if a C Corp is right for you, but you don't want to have those issues with taxation, then an S Corp could be the next best bet because it gives you some of that structure that comes with the C Corp while having a more favorable tax out. And then again, the S corporation has pass through taxes. So the shareholders would file a K1 that accounts for their profits and losses, and then they would pay those on their personal tax return. And then finally, on this piece of it, we've just got a table here that kind of goes through some of the highlights of each one of those entity structures that we discussed. We look at taxation on all of them and can just kind of have a visual representation of what might be the best for your operation. Next, we go over to legal issues and land tenure. What is land tenure and what kind of legal issues could we be talking about? Land tenure essentially is the subject that looks at the legal, social, and economic challenges regarding how land is owned, used, managed, or transferred. Um, a lot of times we've got factors that are kind of present whenever we think about land tenure. Well, they change over time. They've been consistent for a while. Some of those right now could be things like displacement and conflict, not even specifically just in the United States, but how does civil war, war in general, governing structures, how did those kind of weigh on and affect how you use your land, how you sell your land, what you're able to do on your land? Legal issues in land tenure can look like barriers to investment and credit. Without formal ownership titles, smallholder farmers and urban farmers often can't easily secure bank loans or financing. We know this is especially true in Indian country for a number of reasons, but one of the big ones is just physical access to banking locations. A lot of times that can create really big issues in a farm or ranch operator trying to utilize or keep their land. It could look like, any inequality on certain types of laws or legal mechanisms that affect who and what can be owned at a certain type of land or on a certain type of land status. When we think about land tenure, we're really thinking about the actual status, the legal status of the land. Well, these aren't all of the areas that, or aren't all of the statuses that are present in the world. These are common ones, some of the most common. So you've got full ownerships, you've got joint tenancy, you've got a tenants in common structure or tenants by the entirety, which refers to married couple and their ability to utilize their land. And then we've also got implications from tribal restricted and tribal trust land. Um, it's kind of when you're thinking about land tenure overall, you're also thinking about how we pass land from one generation to another. There are significant implications with that right now. We've got a really aging farm and ranching population. We know that I think something like 66 is the average age of the farmer right now. And there's a pretty significant gap between that age group and the age group that is going to be eligible to come up and utilize those lands for farming activities. But all of it just kind of gets to how do we be on the land, utilize it, sell it, make it freely alienable. All of that is really relevant here. Looking at the specific types of land statuses, we first go to joint tenancy. This is a type of title where two or more people hold the entire title equally. It's called an equal ownership right or an undivided interest in the entire property. Joint tenancy is not freely alienable. So you can't just transfer the joint tenancy and expect it to remain as land that's in joint tenancy. That transfer would dissolve it. Joint tenancy does have a right of survivorship, however. So upon death, any joint interest in the property would automatically pass to the surviving joint tenant by operation of deed. This is really, really useful in times of death because it avoids probate. So if you, let's say you and a sibling have an undivided interest in 40 acres of land and your sibling passes away, you now own all total acreage of that 40 acres personally. And so there wasn't a need to probate it. There wasn't a need for any type of formal documentation. It was automatic upon death that that interest transfers to you. The undivided interests are potentially subject to each owner's individual debts or creditors. So in this scenario, a creditor of one is a creditor of all. So if you are in a joint tenancy relationship over a piece of land with somebody, if financial distress comes into the picture and creditors are at play, your personal assets could, or your portion of that tenancy is also in jeopardy. And there is a partition action to dissolve the joint tenancy, but it must be filed by a creditor to satisfy the debt. So while it's possible that you could receive protection from your other joint tenants' liabilities, it's something that would have to come from the creditor's end. We also have tenants in common. This is where two or more persons or entities hold title. This is again an undivided interest. So you have a percent ownership that can be specified, or this is not an undivided interest. So you've got a percent ownership that can be specified. So if you are tenants in common with somebody, it's possible that you own 40 acres and they own 20 acres of the 60-acre plot. There is no right of survivorship with tenants in common. So the co-tenancy upon death is subject to probate. which again, in the best case scenario, that's expensive. In the worst case scenario, it's expensive and drawn out. Um, However, with tenants in common, the interests are freely alienable. That means if you decide that you want to sell your 20 acres of the 60-acre plot, you have every right to do that, and it doesn't require consent, formal or informal, from the other tenant in common. The entire property is not subject to all individual co-tenant debts. So for tenants in common, a creditor of one is not a creditor of all. Creditors can only reach the co-tenant share. And a partition action can be filed by the creditor, but it does not dissolve the co-tenancy. Then we have tenants by entirety. This is similar in a lot of ways to what a joint tenancy would look like, but it's for two married persons only. So, for purposes of legal descriptions, the couple is one person. And that means that anytime death comes into the picture, the interest in the land automatically passes to the surviving spouse upon death, which again avoids that costly and timely probate process. Tenants by the entirety are not subject to debts of an individual spouse, and that applies whether the debt was incurred before or after the date of the marriage. Upon divorce, if divorce comes into play, the tenancy automatically converts to tenants in common. So you would have whatever interest was originally in that land. Typically, if a you own something by as a tenant by the entirety, that means you do have an undivided interest. So if divorce was to come into play, typically this would look like a 50-50 split on acreage. And this is the most fundamental liability in protecting or liability protection in operating a business. Even further than joint tenancy, if you are a tenant by the entirety, you've got kind of ultimate protection, and also you're lucky because you don't have to worry about any type of probate process upon death. Sole ownership. So this is typically the worst case scenario for land tenure, similar to a sole proprietorship whenever you're talking about entity structure. If the operation is structured as a sole ownership, it creates significant issues upon death if the land is being used for a farming operation, which is anticipated to continue after that person's death. So you own a sole ownership, if you own your land as a sole ownership, you've got significant issues upon death if there's no formal will or trust in play. And it really can come to a head whenever you're talking about children potentially taking over a farm. These kind of structures just let in the most room for conflict. And we know, historically speaking, that conflict is pretty ripe at death. So if you do have a sole ownership, it would be typically advisable to look at other entity statuses or other land statuses to try and see if you could convert that to something that provides a little bit more protection. And then finally, we come to land tenure on tribal land. So, in addition to the land status options discussed previously, Native American farmers and ranchers also need to consider whether they are on tribal land. This generally comes down to two different options: tribal trust or tribal restricted lands. And these are two distinct forms of Native American land tenure that are both recognized in federal law. There are many differences between the two, but the primary difference or the primary question is who holds the title. If you're talking about trust land, legal title is held by the federal government for the benefit of the tribe or individual tribal members. And if you're talking about restricted land, that legal title is held by the tribe or the individual Indian, but the land cannot be sold or encumbered without approval from the Secretary of Interior, typically. There are some exceptions for tribes that have agreements in place with Interior for things like land leases. But as a general rule, under federal law, you do have to have Secretary sign off to make the land alienable or free it from any encumbrances. Looking at this, we've kind of got a visual representation of what tribal versus restricted land looks like. Going from left to right, first we've got the legal title holder. For trust land, that's the US government. For restricted land, that's the tribe or the individual Native American. Trust land cannot be sold, gifted, or leased without BIA approval. I'm sure many of you are somewhat familiar with this process, but it's possible for, excuse me, a tribe to take land out of trust status if that is what they want to do. There are a lot of considerations that can make this a positive or a negative, depending on the time and place. But regardless, it's generally a pretty drawn out process to get it taken out of trust status. On the other hand, restricted land cannot be sold or transferred without approval from the secretary. Jurisdiction and immunity is another really big consideration, especially when we're thinking about capital. Trust land is immune from state and local property taxes, and it is subject to tribal and federal jurisdiction, but it's not subject to state jurisdiction. Restricted land, on the other hand, is usually exempt from state and local ad valorem taxes and creditor actions, but it's not as foolproof of a shield as trust land is. And then just thinking about location, trust land is pretty widespread across Indian country, which reaches coast to coast, and is generally where reservations are placed. There are some tribes that have trust land outside of the reservation, but it just varies tribe to tribe. And then for restricted land, it's a lot more common actually with tribes in the eastern United States, and in general is less common than trust land. So what do these types of land statuses in Indian country, how do they implicate your ability to operate your operation? This kind of can be boiled down to three primary points. The first one I'm sure everybody's heard quite a bit about, and that's fractionation. As lands are passed down through generations without being partitioned, ownership interests get increasingly smaller, undivided fractional into undivided fractional interests. So accordingly, consensus for leasing or developing trust or restricted land can be difficult because of this fractionation. Um, Included in that fractionation comes with issues with accessing capital because trust and restricted lands cannot be easily sold, foreclosed upon, or seized by creditors. It's often difficult to use these types of land as collateral for a loan. While there is a process for collateralizing trust and restricted land, many lenders just simply aren't aware of the legal mechanisms for doing that. And even if they are aware of them, there are just not a ton of traditional lenders across the country that have much practice with it. And kind of linking back to fractionation, when in certain circumstances where land is really highly fractionated, there's kind of a belief that some people have that sometimes lenders just, instead of really looking at how they could figure out how to provide you with capital, they'll pass it on because it is an uphill battle for most of them. And then finally, BIA oversight. You can't think about tribal unrestricted land without thinking about BIA and how that bureaucracy can often lead to delays. The organization right now is just really, really overworked. And a lot of times those BIA employees are being pulled in 5,000 different directions, which can lead to further delays in what is often a complicated process to begin with. So it's pretty common for land use changes to be drawn out. That could mean you want to put land in restricted status, which could be a process, or like we talked about before, it could look like you trying to remove, maybe as a tribe, your land from being tribal trust protected. Okay, that takes us through the brunt of our slides. I do want to open it up to any questions that we have, and see if we can get some more discussion going.
Yeah, and you do have a couple of comments in the comment section. Not
Okay.
necessarily questions, just thoughts, I would say.
For a business, I found accountants aren't always tax experts. Mine self-confessed to no knowledge of air transport businesses, and cost me over 9,000 in my first tax year. This is a great point. Um, Certainly, not all accountants are versed in how taxes go. I would definitely, if you're looking at consulting with an accountant, I would certainly try and find a tax specific accountant. And even one level further, find one that is familiar with ag operations. A lot of this language, a lot of tax language is jargon. I mean, even a, you know, equipped and capable tax accountant, if they're not familiar with, everything from corporation deductions on your entity down to, how you draw out a farm truck payment to be, take some off of your tax returns every year. That could look a lot different for somebody who's talking about general businesses versus one who's talking about a farm or ranch operation. Another kind of option on that, and maybe one that's even financially more feasible if you're talking about getting an accountant and an attorney. There are great attorneys that are frequently CPAs, that just kind of live at that intersection between legal documents, compliance, and also really solid audit and tax return type of mechanisms.
If you guys have any questions, feel free to put them in the chat, or you can unmute yourself and ask any questions or have any comments.
And any come through, um, I will definitely feel free to ask them if you have them. I'm going to put my email address in the chat. If you'd like to discuss any of this at a higher level or maybe don't want to talk about it on the Zoom, we'd be happy to follow up with you and provide you with any resources that are at our disposal. There we go.
Go ahead, Stefan.
I really didn't have. I put a comment in the chat a long time ago when he was talking about and the sole proprietor was the wife liable also, and her assets. And I was like, yes, everything is
Yep.
liable in sole proprietorship.
Oh, I see it right there. Yes, totally. It is kind of sole proprietorship and sole ownership is just generally the not the direction you want to go in. It's possible you could, live your life in that structure and not have issues, but that leaves a lot up to chance, especially when there are some, LLCs, for example, like I said during the presentation, they're really favored for their flexibility and their ease in creating. And, I don't give legal advice on these webinars, on issues like this, but it's something that, I talk about with my family. I come from really large family that is mostly made up of farmers and ranchers. And a lot of them, the majority of them, weren't in any type of formal business structure even a few years ago. And while we haven't had major issues happen for anybody on an individual level, it's just kind of risk that you don't have to put up with, and you could get rid of without significant cost to yourself.
This is Stephanie again. I help a lot of beginning farmers with planning and they know what type of activities they want to do, operation like livestock or vegetables or even commodities. So my advice is always do not start this operation as an individual.
Mm.
Create some type of entity. Remove yourself away from the business.
Mm.
Yeah. And then I work with a lot of people with air property. You might want to put the land in a trust, and everybody is a member, and everybody get dividends. Whether you lease the land, put it in some kind of conservation program or whatever. That'll cut back on a lot of bickering and a lot of people thinking you get more than I'm getting.
Totally. And it's a great example because a lot of times the type of status is going to be regional, or, specific to certain groups that have different types of land holdings.
Well, as you guys are thinking of any last questions, I did want to just thank you again for joining us today. I felt like it was a really meaningful topic, and thank you, Ridge, for presenting for us. If you want to be able to rewatch the webinar, I will be sending out an email with a link to the recording on our website. And this will be located on the nativeagfinance.org. And in the video library. And so Rich will probably also, I would guess, share his presentation. So I'll send out a PDF copy of this presentation as well. So you'll have both the recording and the presentation. Those will come out early next week. And we look forward to seeing you guys in August. August 20th is the next webinar. It'll be the third Thursday of the month at 2 p.m. Central Time, as always. And that'll kind of be a overview of FSA to begin with. And so thank you again for joining us. And if you have any last questions or comments, this is your time to share those, please.